First case of the morning is Dave versus Knowlton. Each party will have 15 minutes to present their argument. The appellant may reserve up to 5 minutes for rebuttal. How long would you like to reserve?
No, I would like to reserve the 5 minutes, thank you.
All right, very good. I will be keeping time up here. I'll try to let you know when you're down to about a minute left in your time, since there's nowhere for you to see that.
Okay. And podium, how do you want to?
Yeah, the podium is fine, please, thank you.
Okay, I'm allowed to approach then?
You may start too, yes.
Okay.
The arguments are being recorded.
Okay,
When
thank
you
you.
present your argument, please introduce yourself. Make sure you stay behind the podium so the recording can pick you up.
Okay.
Make sure you speak in loud enough voice so you can be heard as well.
Okay, thank you. Thank you,
You
Your
should
Honor.
not use the name of any child, minor, or victim during your argument. Please use initials or something like the child or the victim or some other designation that will make sense to us.
Okay,
We read your brief. I'm ready to proceed whenever you are.
perfect, thank you, Your Honor. My name is Christine Russo. I am attorney for the appellant, Shane Knowlton, in this matter. As the court's aware, as you said, you've read the briefs. This is a case that came out of a child support trial. Mr. Knowlton was indicted on 2 counts of non-supportive dependence, and he was indicted in 2021. And both counts in the indictment were for periods of time that were prior thereto. And basically, to get into the nuts and bolts of it, if you first look at the whole argument, in terms of Pittman, Swayze, that was the crux of the motion to dismiss that started this case off with Mr. Knowlton. Mr. Knowlton said, hey, this should be dismissed. I was, at the time that I had incurred these child support arrears, it was not illegal at the time, it was not a felony. After Pittman, they would change the law to include was legally obligated to support, although that was not until 2019, years after his charges in the case, well, I should say the indictment in the case, the time period of the 2 separate time periods. And that, I think, you have to look at first before anything else, because as we've been arguing in these, since Pittman, it is, and it's our position, the defense's position here, that if we go back and we punish people for crimes that were not a crime at the time, it is not a remedial, as the state would want to argue, statute in nature. It does change it, and it does create a felony. It's a felony now.
Counsel, I'm a little confused because I don't see assignment of error regarding retroactivity.
Okay.
It's sufficient evidence, weight of the evidence.
Oh, I'm skipping right ahead to, I'm sorry, and I did go beyond those 2, the motion to dismiss with respect to citing of the Pittman case that changed the law of the child support statute from is to was.
Right.
I just think that that's
I just didn't see the analysis in regard to the retroactivity.
okay.
That's okay. That's okay. Go ahead and proceed. I'm sorry. It's probably me.
Well, we do cite State versus Concilio, we do argue the ex post facto issue. Okay.
I understand.
And saying that the statutes are prospective in nature unless they specifically state that they're retroactive, and I believe that was, and maybe it wasn't adequately covered, and if it wasn't, Judge, I apologize. I want to apologize to the court. There's a couple of typos that I didn't catch when I reread this over and over again, but that's the first issue, is,
Okay, cool.
yes, the retroactivity of the statute that was addressed in Swayze, Pittman, and here we are again. We've got multiple of these going with the after-the-fact indictment, so that to me is a big issue, on top of the fact of the ineffective assistance of counsel, which again, I'm hitting the 2 last issues first, because I think they're important, because no defense was presented for Mr. Knowlton. What is the one and only defense to if we get beyond the dismissal, we get beyond Pittman, we say, oh, no, we can now do this, it's not ex post facto, which I disagree with, then where's the defense? Where did he present any evidence that the guy had an ability to pay in the first place? I mean, that is the crux of the whole thing. He just rests after the state and only argues the computation, which I do think is wrong too, of the number of weeks and how the Child Support Enforcement Agency computed the 26 out of 104 weeks, but there was nothing presented on his behalf. He was on public assistance, this guy was in prison. I mean, none of that was presented either. And in a way, I mean, These things are important. I mean, this was, we use.
If that wasn't presented, how do we know those things? You're telling us that, was that in the record somehow?
Yeah, there was, I believe that there was a pre-sentence investigation also in this,
Okay.
when they came back, and there was, a notation that he was on, public assistance, cause when they do the background and all of that.
Okay, so
So-
it's in the PSI, very good.
Yes, yes, thank you. And just, like I said, I mean, I just feel that that was extremely deficient, that those arguments weren't properly made. I didn't find a whole lot of, that was done on the motion to dismiss. I mean, I think that, he could have had better counsel. There should have been more addressed. Like I said, no defense was put up, no witnesses. Mr. Knowlton was just left in the balance of saying, yeah, you didn't pay for 26 out of 104 weeks. Sort of like a strict liability, right? Unless you have to show why he didn't pay. If you determine that the state of Ohio computed those number of weeks appropriately, which again, that was our other two with the manifest weight and the sufficiency of the evidence, we argued those things. But I figured.
Let me ask you this here on the statute. If I understood the prosecutor's brief, there was a period of time which the child support payments were for current support in 2015. Then in the count two is all 17 and 19 and 21, or whatever years those are, and that clearly is all payment on arrears and not on current support.
Correct.
Is the retroactivity argument go to just the payment for arrears? Would any conviction for failure to pay current support in 15, would that retroactivity argument apply to that?
I would think it would apply to that also. Because then they could have indicted at that time. But see, this is the problem that I have with this case also. How does a parent lose their parental rights in terms of not being able to object, right? Don't pay support for a year, you don't see the kid for a year. So we're using his failure to pay support to be able to say, you're losing this kid, you have no rights to this kid ever again. It's not your flesh and blood, you're done in 2016, and you don't owe any current support, it's reduced to zero, it's to in arrears, but now we want you to pay it. Do you see what I'm saying? And I know I can't do nothing about that. That kind of sticks in my craw a little bit too. Because you know what I mean? You're using that against the guy to take away his parental rights, but then you're saying, but you still gotta pay it. You know, and now let's add insult to injury, and now let's indict the man on a felony to now say, well, you didn't pay at that time.
Well, but the thing is, somebody paid for the support of that child. Either the mother or the state.
I don't think that there was any evidence that the state of Ohio,
Okay,
that there was
well,
any paper to the
regardless,
state.
somebody
Okay.
paid for the support of that child.
Correct.
So if he loses his child, he's absolved of all responsibility in regard to when he should have been supporting him for many years?
Like I said, I can't do anything about that. That's kind of like a personal pet peeve, because I feel that when you do that, there should be some.
You're almost incentivizing somebody to just not take care of their child then, because then you're not gonna be responsible for it.
Well, I don't think so. I think when somebody loses their child, do you know what I'm saying? And they could have enforced it. I mean, a lot of these indictment cases, you look at the background, these people are never brought to DR court for any type of civil contempt. They're never brought in for any type of misdemeanor contempt to say, hey, you gotta pay. They're gonna wait 6 years and then indict on an obligation that's been long past due for a child he does not owe any obligation to currently, and just paying mom and I guess new dad back for the support at the time. Yeah, it's not fair. I mean, none of it's fair, but it is what it is. And at the time, they could have indicted him prior to 2019 when they didn't have to wait 6 years. You get your 24, or you get your 104 weeks, your 2 week period. They could have brought him in and tried to enforce that order. That order was never enforced. It was never enforced until long after the child was adopted, and then they come and indict him in 2021, I believe. No, 22. It was 21. But anyway, years after. So, I still don't think, even though it may have been a current obligation at the time, that would absolve Pittman, because at the time that they indicted him, it was an arrears-only case. There was no current obligation. And at the time, 2015, 17, prior to 19, you can't charge for the back money, because that wasn't allowed until they changed the statute to be able to do that, I guess. would be the right way to say it.
You have about a minute of your time left.
Okay, the only thing I would like to also just touch on briefly is that the computation of Mr. Knowlton's weeks and things like that, and the way that they apply the money. You have somebody that may not be, you know, into a job where you're getting, you know, a wages garnished every month. So if you may have where, oh, I missed a month, you know, if you're self-employed, let's say, and I got a big check this month, now I'm gonna catch up. I'm gonna catch up for last month and pay this month too. They're not crediting any of that, they're just saying, oh, well, you paid over. And even though that may have satisfied the obligation, but you didn't pay it in that month, so that's how we're counting the weeks. And then to crumble in the prison time on top of it, which was clearly, he's confined, he has absolutely no ability, they say they take that off the weeks, they still have enough weeks, but again, why aren't, that's gotta be spread across, do you know what I'm saying? In terms of when those lump sums come in, because somebody should be able to catch up. If I owe $300 a month, and I miss a month because I didn't have any money come in, but now this month I can pay $6 and catch that up. Should that be for the weeks that that should be, say you failed to support? So, you know, that overage issue, of having whatever more he pays doesn't count type of thing, I don't believe is constitutional either, because it does leave him in a constant deficit situation as explained. So, I'm probably out of time.
You're in your
Okay.
rebuttal time
Yeah.
now, but
All right.
thank you.
Thank you.
May it please the court, my name is Stephanie Zeranek, and I'm from the Medina County Prosecutor's Office representing the appellee in the state of Ohio. Shane Knowlton assigns 4 assignments of error, all of which should be overruled. First, Knowlton's convictions were supported by sufficient evidence. Since Knowlton did not make a motion for acquittal under Criminal Rule 29, he has waived any challenge to the sufficiency of the evidence on appeal. During the time period of count 1 of the indictment, when the child support order was for current child support, which was March 1st, 2015 through March 4th, 2016, Knowlton did not pay for 43 weeks. Only 26 weeks of non-payment are required for non-payment to be a felony under Revised Code Section 2919.21G1. During the time period of count 2 of the indictment, Knowlton did not make any payments. The CSEA caseworker kindly subtracted the 19 weeks that he was incarcerated during that period of time to get a total of 85 weeks unpaid, which again is above the level of 26 weeks of non-payment. The defense noted that there are issues with overage, and the overage amounts paid are applied to the owed balance carried over from previous months, but they would not show up on the payment history that was reviewed at trial. He also argues that he paid throughout 2016, but he only paid during 5 months of 2016. Second, the manifest weight of the evidence is in favor of Knowlton's convictions, because the state presented evidence showing that Knowlton had not paid for 43 weeks of the time period in count 1 of the indictment, and 85 weeks of the time period in count 2 of the indictment. Knowlton incorrectly states that he did not have a current support duty between 2015 and 2017, but he did have a current support duty from March 1st of 2015, which was the beginning of count 1, to March 4th, 2016. Thirdly, the trial court was correct to deny Knowlton's motion to dismiss the indictment. The retroactivity of Revised Code 2919.21B's 2019 amendment regarding arrearages does not actually apply to this case. Knowlton did not pay for 43 weeks while he had a current child support obligation, which was before the amendment took effect, and did not pay for 85 weeks while arrearages were due, which was after the amendment took effect. Fourth, Knowlton was not denied effective assistance of counsel. Under Strickland v. Washington, there are 2 prongs. Counsel's performance was deficient, and deficient performance prejudiced the defense. In Ohio, a properly licensed attorney is presumed competent counsel. Knowlton argues that counsel failed to make objections throughout the trial, but does not point to any specific instances. He also has not shown any prejudice resulting from counsel's decision to rest without presenting witnesses. He argues that counsel should have raised the issue of his means-tested public assistance, but the last time he raised this issue was in 2015. It was not actually mentioned in the 2016 judgment entry terminating current support. Defense counsel also does not have to make a criminal Rule 29 motion when that motion would be futile. The state had already presented copious evidence showing that Knowlton had not supported his dependent. Therefore, not making a criminal Rule 29 motion was not ineffective assistance of counsel. Therefore, if there are no questions, the state of Ohio would respectfully ask this court to affirm the judgment of the trial court.
Why would defendant have to have made the argument in 2016 about it being tested insurance when child support came up, particularly being reduced to a zero support order, current order? Why would he have had to raise that then? Why would that preclude him from raising it now once the state brought these charges?
Your Honor, I believe that it would be important to raise it then just because of the issue of being ordered to pay the arrears. So, although the current child support was terminated in 2016, there was still the issue of paying his arrears that he did not cover.
On the issue of retroactivity, in 2019, when the charges were all arrears payments, at the start of 2019, when that count two period began, was the state permitted to charge him with failure to pay child support arrears or just current child support?
We believe that the state was permitted to charge him with the arrears because that amendment took place on February 11th, I believe, 2019. And his, the count two of the indictment started March 1st of 2019.
So all those periods are for periods after the amendment to the charge?
Yes, Your Honor, count two is entirely after the amendment to the statute.
Thank you.
Thank you.
Seeing no further questions, thank you.
Just briefly, Your Honors, I just wanted to touch on the state had indicated that Mr. Knowlton can't argue the sufficiency of the evidence because he did not raise a Rule 29 motion. And then says, well, his lawyer's perfectly great because he didn't have to argue a Rule 29. It's kind of a double-edged sword. Basically saying, hey, you lost this issue on appeal because your dumb lawyer didn't, I shouldn't say that, strike. Your lawyer didn't follow Rule 29, but he did a great job. Do you see what I'm saying? That right there on its face shows, if the state is accurate, that he loses that sufficiency of the evidence argument because of that failure to raise a proper Rule 29 motion, that's a problem. That's a huge problem.
Isn't the law actually that you don't lose it? That you can actually still raise it on appeal?
Hey, you guys are the experts, I'm just saying, they're saying that, and if that's the case, I think that there's an issue. Also, I wanna touch on the fact of the first count in the indictment, they're arguing from the 2015 to the 2017, count one, that there was current support. There wasn't 104 weeks of current support in there. The support order was terminated in March. The child was adopted out in 15. They didn't terminate the support order until after the adoption in 2016. There's not, from 2000, at the start of the indictment to the date that the child, that's not 104 weeks. Then they extend it with the arrears to the 2017. Do you see what I'm saying? And that would fall also hugely in the face of Pittman because that is prior to, and that's exactly what they said they couldn't do. Just because they indict thereafter doesn't make it okay. It's just like if we had a suppression argument, just because police officers find contraband thereafter doesn't make the illegal search okay. Do you see what I'm saying? So I think the computation of saying that there's enough weeks in that 2015 and 2017, by law there's not enough weeks. Because you have to have 104. You can't just say, well, there was 26 weeks when he had a duty to pay the current support in that first half of it. And then the second indictment was from the March 19th to February 21. That's where I'm stating just because they're filing it after Pittman doesn't resolve the fact that at the time that was not a crime and the support order had terminated prior to. Do you know what I'm saying? So if people need to be aware, if you can face a prison sentence, which is what he got, okay, at the time that he did not pay child support and was indicted, was not a crime. It was already over. So to now say, okay, now you're gonna go to prison.
But he had an ongoing order to pay the arrears, is that fair?
They had, yes, they had an order to pay the arrears, which there's remedies to that. There's contempt of court, there's civil remedies, you can still jail, they can
But
still jail them.
as of February or March of 2019, the legislature has seen fit to say it is a crime to not pay on your child support arrears. Is that a
Yes.
fair statement?
Yes, they did,
That is another remedy the legislature has decided to have in these particular cases.
Correct, to resolve it. But that's an effective date in February of, I think she was correct, 11th of 2019, that was effective. So it would be from that date forward, there is no specificity to any retroactivity.
So your view would be that would only apply to people who started having arrears after that date. People that had arrears before would not apply to that.
Correct.
Understood?
Any other questions?
No. See none?
Appreciate it, appreciate your time, thank you so much, I really appreciate it, thank you.
And thank you. The court will take the matter under advisement and issue a decision in due course. The clerk of court will mail a copy of that decision to you when it's completed, and also it will be on the Ohio Supreme Court website.